Imagine this. You wake up on a Tuesday morning. You walk to the mailbox like you always do. But today, there is a letter from the Social Security Administration. You open it, and your stomach drops. It says your benefits are being reduced starting next month. You have paid into Social Security for over 30 years. You did everything right. You worked, you paid your taxes. Every single paycheck, money came out for FICA for decades. And now, a single letter tells you the money you were counting on is being cut. You think to yourself, they can't do this. I earned this. This is my money. But here is the truth most Americans never learn. 3 words, just 3 words, hidden inside the original Social Security Act since 1935 gave the government the legal power to do exactly that. And the United States Supreme Court already confirmed it. But please, do not panic. Because those same 3 words, once you understand them, become your greatest weapon to protect your benefits. I am Edward. I am a senior policy analyst and retirement finance researcher. I study the actual laws, the actual court cases, and the actual government policies that affect your Social Security, your pension, your Medicare, and your retirement security. I do not deal in rumors. I do not spread fear for clicks. I go directly to SSA.gov, to Supreme Court rulings, and to official federal policy documents. And then I bring that information to you in plain, simple English. Today I am going to reveal to you exactly what those 3 words are. I am going to show you the Supreme Court case that changed everything. And most importantly, I am going to give you 3 specific steps you can take right now to make sure your benefits are protected. But please, stay with me until the very end of this video. Because there is one hidden mistake that millions of seniors make after receiving a letter from Social Security. And that single mistake can make a temporary problem become a permanent loss. Let us begin. Let me tell you about Robert. Robert is 67 years old. He lives in Ohio. He retired 2 years ago after working 34 years as a machinist. He paid into Social Security his entire adult life. Every paycheck, that FICA deduction came out. He never missed a day of work. He never cheated the system. He did everything by the book. When Robert retired, he started receiving his Social Security check every month, $2,140. Like clockwork, it paid his rent, it covered his medications, it kept the lights on. Then one day in March, Robert received a letter from the Social Security Administration. The letter said that SSA had determined he had been overpaid by about $6,000 due to an earnings calculation adjustment. The letter said his monthly benefits would be reduced by 50%, cut roughly in half, until the overpayment was recovered. Robert was shocked. He sat at his kitchen table and read that letter 3 times. He could not understand how this happened. He had never lied about his income. He had never hidden anything. But here is where Robert made the mistake that changed everything. He did nothing. Robert believed, like millions of Americans believe, that because he had paid into the system for 34 years, his benefits were guaranteed. He thought this must be a mistake that would fix itself. He told himself, I paid in. They owe me this. They will figure it out. Robert did not file an appeal. He did not submit Form SSA 561. He did not request a waiver on Form SSA 632. He did not call Social Security within those critical first 10 days. And because he did nothing within 60 days, his right to appeal that decision expired. His benefits stayed cut, and the overpayment was deducted from his monthly check for the next 12 months. Robert lost over $12,000 in benefits, not because Social Security was wrong and not because he did anything illegal, but because he believed a myth that says your Social Security benefits are a guaranteed contract that no one can touch. The United States Supreme Court said otherwise, and today I am going to show you exactly what the court ruled and exactly how to make sure you never end up like Robert. Let us go straight to the source. When President Franklin D. Roosevelt signed the Social Security Act into law in 1935, most people focused on the benefits, the retirement checks, the safety net, and that is understandable. But buried deep inside that law, in Section 1104, Congress inserted a single sentence, just one sentence, and it contains 3 words that define the legal reality of your Social Security benefits to this day. Here is what Section 1104 says, and I am reading this directly from SSA.gov, word for word. The right to alter, amend, or repeal any provision of this Act is hereby reserved to the Congress. Alter, amend, repeal. Those are the 3 words. This is called the Reservation of Power Clause. And what it means in plain English is this: Congress gave itself the permanent legal authority to change any part of Social Security at any time. They can increase benefits. They can decrease benefits. They can change the rules of eligibility. They can restructure the entire program. Now, you might be thinking, surely the Supreme Court would not allow Congress to just take away benefits that people paid into for decades. Surely there is a constitutional protection. That question was answered in 1960. The case was called Flemming versus Nestor, and it is the most important Social Security case in American history. Here is what happened. A man named Ephraim Nestor immigrated to the United States in 1913. He worked and paid into Social Security for 19 years. He became eligible for benefits in 1955 and started receiving his monthly checks. Then, in 1956, Nestor was deported under a law that applied to individuals who had been members of the Communist Party. Under a 1954 provision, his Social Security benefits were terminated. Nestor fought back. He argued that he had paid into the system for nearly 2 decades. He said his benefits were a contract. He said the government could not just take them away. The case went all the way to the Supreme Court, and the court ruled against him. Here's what the Supreme Court said, and I am reading this from the official text published on SSA.gov. To engraft upon the Social Security system a concept of accrued property rights would deprive it of the flexibility and boldness in adjustment to ever-changing conditions which it demands. The court went further. It stated that a worker's interest in Social Security benefits, and I quote, cannot be soundly analogized to that of the holder of an annuity, whose right to benefits is bottomed on his contractual premium payments. Let me say that in simpler terms. The Supreme Court said your Social Security benefits are not like a private annuity. They are not like a savings account. Paying FICA taxes for 10 years, 20 years, even 40 years does not create a legal contract between you and the government. Your benefits are a form of social insurance, and Congress, under the Reservation of Power Clause, can change the terms of that insurance whenever it decides to. Now, I know that sounds frightening, but before you panic, I need to tell you the other side of this story. Because while the Supreme Court said benefits are not a contractual right, there are powerful legal protections that still exist. And these protections are what actually save your benefits. Here is what most people do not know. The Social Security Administration's own internal policy manual, a document called POMS DI 405150001, published on SSA.gov, says this: an individual's interest in continuing to receive Social Security or supplemental security income benefits constitutes a statutorily created property interest. The Fifth Amendment protects that interest. Read that again. The SSA itself says your benefits are a property interest protected by the Fifth Amendment of the United States Constitution. That means the government cannot take an adverse action against your benefits. It cannot reduce them, suspend them, or terminate them without giving you due process. And what does due process mean in practice? It means 3 critical things. First, the SSA must send you an advance written notice before it takes any action against your benefits. This comes on a specific form called the SSA L8155, the Notice of Planned Action. That notice must tell you what they are doing, why they are doing it, and how it will affect your payments. Second, you have the right to appeal, and not just once. You have 4 levels of appeal. The first level is called a reconsideration. You file it using Form SSA 561. A completely different team at Social Security reviews your case from scratch. If that does not work, you move to Level 2, a hearing before an administrative law judge, which is an independent judge. According to AARP, the approval rate at this stage has averaged around 50% since 2020. That means half of the people who get to a judge hearing win their case. Level 3 is the Appeals Council review. And Level 4, if it comes to it, is filing a civil action in federal district court. Third, and this is the protection that most seniors have never heard of, if you file your appeal within 10 days of receiving that adverse notice, your benefits continue at the full amount while your case is being reviewed. They do not get cut. They do not get reduced. You keep receiving the same check. This is called Goldberg-Kelly payment continuation. It comes from a 1970 Supreme Court case called Goldberg versus Kelly. And the SSA's own rules are so strict about this right that their internal manual says, and I am quoting directly, technicians must never suggest waiver of GK payment continuation or ask specifically if they want to waive GK payment continuation during appeal. The SSA is not even allowed to hint that you should give up this right. That is how important it is. And there is one more protection I want you to know about. If the SSA says you have been overpaid, you can file a Form SSA 632 to request a waiver. If the overpayment was not your fault and paying it back would make it hard for you to afford necessities, SSA may forgive the entire overpayment. This is not a favor. This is your legal right under federal regulation. Now let me show you what happens when someone does not use these protections. Congress used this very same reservation of power for good in January 2025, when the Social Security Fairness Act was signed into law. That law repealed 2 provisions, the windfall elimination provision and the government pension offset, that had been reducing or eliminating benefits for over 2.8 million Americans. Retroactive payments going back to January 2024 were authorized, and billions of dollars flowed back to people who had been underpaid. That is the same congressional power at work, this time in your favor. But the point remains, Congress can change the rules in either direction, and the only thing standing between you and a benefit reduction is your knowledge of the appeal process and your willingness to act quickly. So here is exactly what I want you to do. 3 steps. Write them down, save this video, share it with your spouse, your family, anyone you know who depends on Social Security. Step 1. Read every letter from Social Security carefully and mark the date you received it. This is not optional. When the SSA sends you a notice, especially a Notice of Planned Action on Form SSA L8155, your clock starts ticking the day you receive it. You have 10 days to file an appeal if you want your benefits to continue uninterrupted. You have 60 days to file a request for reconsideration before you lose your appeal rights entirely. Do not throw that letter in a pile. Do not wait for it to fix itself. The moment you receive it, write the date on the envelope. Then read every word. Step 2. File your appeal immediately. Use the correct form. If you disagree with any decision SSA has made about your benefits, file Form SSA 561, Request for Reconsideration, within 10 days to keep your benefits flowing at the full amount. You can do this online at SSA.gov, or you can bring the form to your local Social Security office. If SSA says you were overpaid and you believe it was not your fault, file Form SSA 632, Request for Waiver of Overpayment Recovery. You can file this at any time, but do it as soon as possible. Do not assume the system will correct itself. Do not assume your years of paying in will protect you. As we have learned today, the Supreme Court ruled that paying into the system does not create a contractual right. Your protection comes from filing the correct forms within the correct deadlines. Step 3. Keep copies of everything. Build your paper trail. Every letter SSA sends you, keep it. Every form you file, make a copy before you submit it. Every phone call you make to Social Security, write down the date, the time, the name of the person you spoke with, and what they told you. If your case ever goes to an administrative law judge hearing or beyond, your paper trail is your evidence. It proves when you were notified. It proves when you responded. It proves you acted within your rights. Remember, the SSA's own policy says they must protect your due process rights, but you have to exercise those rights. Nobody will do it for you. Now, I want to speak to you directly for a moment. What I have shared with you today is not something most people learn until it is too late. Robert did not know about the Reservation of Power clause. He did not know about Flemming versus Nestor. He did not know he had 10 days to file an appeal to keep his benefits intact, and that lack of knowledge cost him thousands of dollars. I do not want that to happen to you. But here is the reality. YouTube can change its algorithm at any time. You might subscribe to this channel and still never see my next video in your feed. A notification can get buried. An important update can slip right past you. That is why I created something specifically for you. In the description below this video, you will find a link to join the Global Senior Alerts Official WhatsApp channel. When you join, you will get access to a free downloadable Senior Benefits Protection Guide. That guide includes every form number I mentioned today, every deadline, and every step you need to take if your benefits are ever threatened. You will also receive real-time alerts whenever there is a major change to Social Security rules, Medicare policies, pension tax laws, banking regulations, or travel rules that affect seniors. No algorithms, no guessing, direct alerts straight to your phone. This is free. This is for you. And it exists because I believe that every senior in this country deserves to know their rights, not after they have lost their benefits, but before. Click that link in the description right now. Join the channel, download the guide, and share this video with someone you love who depends on Social Security. Because now you know the truth. 3 words, alter, amend, or repeal, gave Congress the power to change your benefits. But the Constitution, the due process protections, and your right to appeal give you the power to fight back. Use that power. Do not be Robert. Be the person who knows their rights, acts within the deadlines, and protects what they have worked a lifetime to earn. I am Edward. Thank you for watching. I will see you in the next video.